not down. This thing. Good morning, everyone. So just a reminder, today, I don't usually nudge you, because last time I'll nudge you, I promise. Judge Poe's going to be here, and Judge Smith's going to be here, and Judge Jones is going to be here. So, like, almost all the Fifth Circuit judges will be in the building today, right after this class, at 1 o'clock. So you should come. It's in Emily Sloan. Oh, not in Garrett Towns? Not in Garrett Towns. Okay, we're moving some. Thank you for reminding me.
Yes. Was that supposed to be business casual?
You can wear whatever you want.
Okay, just didn't seem like everyone else in the
It's okay. You don't have to dress up. That's fine.
All right, thank you.
All right, but you should all come. These are three very, very, very distinguished jurists, and I think you will enjoy their presentations today. I'll be talking to Judge Ho, go through a lot of different things. Any questions before we get started? All right, my friends, we are basically, if not done, close to being done. There's not that much left for us to do. We're covering equal protection in class today. We'll do some equal protection class on Wednesday. And then after that, we go into due process, and that's it. So we are really at the final countdown, if you will, the final moments of this class. It always goes so much faster than I expect. I get to know you, and then you disappear. It's a weird part of this job, but I've enjoyed it at least so far. All right, what I want to do now is to sort of recap our last few classes and talk about scrutiny. Now, I don't get hung up on scrutiny as much as other professors do. I do that for two primary reasons. One, I think the current course is abandoning scrutiny. This stuff hasn't mattered in maybe 50 years, right? The actual tiers of scrutiny really haven't mattered since like the 70s. So I don't focus too much on them. Second, scrutiny is kind of just a shorthand, right? It's simply of asking how are courts going to resolve cases? Who bears the burden? How strong is that burden? That's really what it's asking. I think far too many law students just memorize these tests and have no idea how to apply them. Trust me, on the exams, they just recite from memory, they copy from the notes, and they don't actually apply it. So I care more they understand how these rules are actually being applied than how you actually know what the standards are. Now, what complicates things a little bit is that there's scrutiny for equal protection and the scrutiny for due process clause. Use the same terms: strict scrutiny, rational basis, and intermediate. But the tests are different. And just give you a preview, for First Amendment, for speech, and for religion, there's also scrutiny. There's strict, intermediate, and rational basis scrutiny, and they all mean different things. So when I say strict scrutiny, it can mean one thing for equal protection, something else for due process, a third thing for free speech, and a fourth thing for religion. I'm sorry. That's what the Supreme Court's done to us. The perhaps happy note is none of it actually matters anymore. The court has largely abandoned scrutiny. They're moving to what they call history and tradition test, which is different-ish, but I want to teach it to you as well. Okay? So if you see on the board, I have these three bullets. If you can't see it, make it a little bit bigger. I think you'll all see it well enough. Okay, I want to start with number 3. So the number 3 is often called strict scrutiny. Before you know what strict scrutiny is, you have to know what triggers it. In other words, what kind of classifications will require a court to review a law with strict scrutiny? The easy answer is race. Under modern doctrine, when the court classifies people based on their race, we have what's called a suspect classification. When the court classifies people based on their race, we have what's called a suspect classification. When you see suspect, think of the word suspicious, right? There's a crime, you're suspicious, you have a suspect, right? A suspect classification. Race is the quintessential example. There's also nationality, which is, again, basically race and things of that nature. But basically, what do you look like? What's your skin color, right? To be kind of crass, but true. We know, going back to Korematsu, that when you have a racial classification, you review it what they call exacting scrutiny. That's what they use in Korematsu, exacting. The modern term we use what we call strict scrutiny. We strictly scrutinize. We very closely look at the law to determine why is the government using race as a factor, right? Why is race a factor? Okay. Who has the burden with strict scrutiny? This is important. With strict scrutiny, the burden is placed on the government. The government must show why they're using this classification. Again, the government must show why they're using this classification. This is what we call from long ago the presumption of liberty. When there's a racial classification, there's not a presumption of constitutionality. It's quite the opposite. We presume that the law is invalid. We presume that there's no good reason why race is being used unless the government can show otherwise. Okay, so again, with a racial classification, we use a presumption of liberty. The burden is on the government. What is the burden? What they have to show? This you'll have to just memorize. This next sentence. That the policy is narrowly tailored to serve a compelling governmental interest. That the policy is narrowly tailored to serve a compelling governmental interest. So there's really three sort of elements, right? First, what is the government trying to achieve, right? Why are they using race? I'll use affirmative action as an example, right? What is the compelling interest that was upheld in the Bakke case and in Grutter and Gratz? At the time, no more, but at the time, it was certain educational benefits that flow from a diverse student body. And the court said that was a compelling interest. What about Korematsu, right? What was the compelling interest in Korematsu to justify the race? The court said it. National security, protecting the homeland during the war, right? Compelling means really important. Now you might say, wait a minute, Josh. Diversity is all good, but is that really the same thing as national security? Ask Justice O'Connor. Oh, you can't anymore. She's not here. But in theory, you could ask her, right? But the court in the history of the United States found two interests compelling enough to justify the use of race. National security in Korematsu and diversity in Grutter and Gratz and Bakke. That's it, right? So the usual rule is there's not going to be any interest that is strong enough to justify the use of race. Think of Loving, right? Interracial marriage. Think of the Brown case with segregation. The state's interest in having children not be biracial or in preserving preventing violence in schools. The court says that is not enough of an interest. The next element is you have to have what's called narrow tailoring. This is really where Grutter and Gratz split. Even if we assume that diversity is a compelling interest, the approach you get there must be narrowly tailored. You must not use race more than you have to. Think again of a narrow suit, very, very tightly tailored suit. You only use as little race as possible. That's what happens. In Bakke, the quota, that's way too much race. It's a set aside. In Grutter, the undergraduate, they give you a straight up bump on your points, right? You get 20 points for being a minority. That is too much race. By contrast, Justice O'Connor told us, the law school uses race as one of many factors, in theory at least. And because race is used in a very narrowly tailored fashion and only one of many factors, they upheld the law school even as the court said that the undergraduate institution was unconstitutional. Okay? So what are the means? The means are considering race. Okay? You can consider race so long as it's narrowly tailored to serve that compelling interest. Or at least that was the rule until a couple of years ago. We'll get to the Harvard case next class. But this is what I'm telling you. Don't get hung up on this because the court's basically jettisoned this entire doctrine. It doesn't matter anymore. But you still need to know it. Okay. You'll need to memorize bullet number 3 cold, right? In other words, if I give you a fact pattern with a racial classification, that's a suspect classification, so we have strict scrutiny, the burdens in the government, and show there's narrow tailoring to serve compelling interest, right? That's got to just be automatic, right? You need to be able to recite that from memory. You'll have your notes, of course, in your exam, but it won't help you. They really won't. Someone mentioned their outline before. Your outline will not help you in this class. I'm sorry. You can make it the most beautiful, big, beautiful outline in the world, right? And it's not going to do much good for you. What will help you in the exam is taking as many of my old exams as possible and really working through the questions. That will That will get you to a good place. If you're sitting there in the exam flipping through an outline, you're going to run out of time. There's just no, I can tell you with years of experience that will happen. So don't worry about the outline too much. Any question on bullet number 3? No? Everyone can bullet number 3. All right, I'm going to jump over 2 and go to number 1. I'll come back to 2 in a few moments. The usual rule, I say the usual rule, is if something is not suspect, it goes up here, right? So you have the suspect classifications, and basically everything else is not suspect, with the exception of maybe sex. We'll get to there in a minute, right? But generally, everything else is going to be non-suspect. And so the example I like to give everyone is age. Age. Right? So for example, what age can you get a driver's license in Texas? I should know this. I don't. Is it 15? 16. Okay. In New York, I think now it's 18. Right? I got mine. I feel like I wrote this a couple times. The only test I ever failed. I failed it twice. But I got mine. It's true. I failed it twice. Oh, this was bad.
What did you do?
Oh, so stupid. The first time I took it, it was in Brooklyn, and I should have done that. As I was pulling out, the very first minute, I literally hit the car in front of me. It was a parked car. It was just a love tap. And I basically failed immediately. And the guy had pity and just let me finish the test for practice. But he said, you failed, but just keep going. And then the second time I did in Staten Island, which was better, I did everything right. I was about to pass. And then the last minute, he was already writing my thing up to say he passed. I blew a stop sign. I got so excited. So it took me a third time. So I was 17 in 3 months. I finally got, because you got to take it once a month. So it's 16. So Texas is 16. New York is 17. Now it's actually 18. Why does New York have a different set of driving age than Texas? Well, one obvious reason: public transit. We don't really have it here in New York. There's public transit everywhere. We don't have school buses in high school. That's not a thing, right? We don't take public transportation everywhere. Maybe New York decides that its roads are more congested. Maybe New York decides that its roads are less safe, and we can't have these young people who are kind of reckless. You all are, right? Driving. Is that unlawful age discrimination, right? That in New York, 16-year-olds can't drive, but in Texas they can. And the short answer is no, right? Why? When you discriminate on the basis of age, it's at most a temporary discrimination, because every 16-year-old, God willing, becomes 17 one day, right? It's not a permanent class. It's just something temporary. And I think we all agree that there are clear benefits to older people doing stuff. We all agree with that? Yes? Between a 16-year-old driving and a 17-year-old driving 18-year-old, we'll see there's some differences. And even if you don't agree with me, could a government rationally believe there's a difference between a 16-year-old and an 18-year-old? Yes. Is that some sort of bias or discrimination? No, I think it's a judgment that younger people tend to be more mature. I don't think I'm going to have to fight you on that one too much. For that reason, when the government classifies people on the basis of age, we call that a non-suspect. It's not suspicious. There are very good reasons why we treat people different on the basis of age. So how do you review an age classification? What's called a rational basis scrutiny. Rational basis scrutiny. Is there some rational basis to justify this law? What precedent is this based on? Lee Optical, right? Is there some rational reason to treat ophthalmologists different than optometrists? Of course, sure there is, right? They might decide that when you fit the glasses, that you have to have medical training and so on, right? It's a rational basis. You might not like the standard, but that's the standard that's applied for all non-spec classifications. So what's the approach with rational basis scrutiny? The burden is not on the government. No, the burden is on the challenger to show that, this law is unreasonable. This law is irrational. Good luck satisfying that test. The rational basis test is, I won't say impossible, but almost impossible to satisfy. Why? It's a test designed to let the government prevail, right? The very nature of the test is courts will not second guess these non-suspect classifications. There's nothing suspicious there, right? So what's the framework, the test? The test is the government policy of the means is rationally related to serve a legitimate governmental interest. Just compare them, right? With strict scrutiny, the interest must be compelling. But with rational basis, it has to be only legitimate. That's a lot lower, right? National security, That's compelling. Road safety, probably compelling, maybe a little bit less, right? It's a lesser interest. And frankly, anything the government does is legitimate. You're not going to find some, maybe something completely bonkers, right? We want to just, give people driver's license based on flipping a coin, right? Just some completely random thing, maybe. But almost everything's legitimate. Also, that tailoring. It's not about narrow tailoring. It's about rationally related. You see the difference between those two, right? Rational relations. Is there some conceivable relationship of why 16-year-olds should not be allowed to drive? Yeah, maybe they're not as mature. Maybe they haven't finished 2 years of high school yet, right? Maybe they don't have as many hours on a road test, right? There are different things that the government can do when it's a non-suspect classification. Critically, with a rational basis standard, we have presumption of constitutionality. It's constitutionality. I'm missing the last couple letters. Presumption of constitutionality, right? We presume that the government can separate people. Again, it's a non-suspect classification. It's not suspicious.
So you're saying that it's going to be very hard for the challenger to prove that, because if the government can just show some rationality,
Correct.
It's
actually even worse than that. The court can make one up. Even if let's say the government says we like this law because of reasons 1, 2, and 3, and the court can say we find number 4 persuasive.
Okay.
Stephen?
Isn't that more the irrebuttable presumption?
That's more or less where we are. Yeah, if you want to put the irrebuttable in there, you can. Right? But when you have a non-suspect classification, I don't want to say Randy and I fought over this. It's almost 100%. It's not 100%, but it's close to it. Right? If you ever litigate a rational basis test and you're the challenger, good luck, because you're not going to win. If you're the government, oh man, you love this one. Government lawyers, it's like, Your Honor, we have a rational basis. Okay, that's good. All right, put your pencils down. We're good. But this is by design. This is what Lee Optical did. It's to remove the courts from scrutinizing. Lee Optical was basically equal protection and due process kind of all in one. It's kind of all standard together. Yes, Anna?
So this is the reasoning behind why there's a 21 limit on alcohol consumption.
Yeah, and actually not tobacco, isn't it? They raised it to 21 now. Right. Yeah, why is it that you could have a federal ban on alcohol, a federal ban on tobacco at 21, but military is 18, right? This sort of thing. Age, they can play around with it. They got discretion. We'll do a case in class next class about alcohol, particularly, where there was a state where alcohol for girls was one age and for guys was another age. And we'll see but that becomes a sex discrimination. One second, Taylor. A related issue also, there's a case the court mentioned at this district called Scrimeti, which prohibits certain types of gender transition treatments for minors. And the question is that a sex discrimination or an age discrimination? Tennessee says, no, this is just an age. If you're over 18, get whatever you want. And the challenger, no, this is actually sex discrimination. Why? Because they want to go in bucket number 2. So very often in this sort of litigation, you're fighting over, is this an age classification? Or is this a sex classification? Yeah, Taylor, I think your hand was up. Yes, ma'am. Yeah, when I say rational, you go say conceivable, it's all sort of in that same gestalt, the same thing. What complicates you is the court uses different terminology, slightly different terminology to describe the same thing. And sort of keep all these sets. I make this as tight as I can, but you're rebuttable. You're adding a word here. You're adding a word there. It sort of makes it more unwieldy. But you're all correct. All right. Everyone get rational basis standard on equal protection for the first bullet. All right. I'm going to introduce number 2 now, but I'll come back to it more tomorrow. Or not tomorrow, on Wednesday. It's Wednesday, right? I think it's Wednesday. Until the 1970s, there were only 2 tiers, 2 levels of review, right? There was rational basis and race. Race was basically only for, strict scrutiny was only for race. That was basically it. There were some other things not really important now. Everything else was basically Caroline products, footnote 4, presumption of liberty, optical. But starting in the 70s, the court started flirting with the idea that maybe there's some middle tier. And this happened in a couple cases. And we'll do this on Wednesday, where the course says, well, sex is different. Sex is not rational. It's not strict. It's somewhere in the middle. They just made it called intermediate scrutiny. It's not really a thing, but they made it up. And you might ask, well, what is sex? Is sex a suspect classification? No, they have this god-awful label, a quasi-suspect classification. What the heck does quasi mean? Almost suspect, kind of suspect, right? I hate these labels. They're so stupid, right? And they said a quasi-suspect classification, right? That there might be reasons why you're using sex, but also might be a type of discrimination against women. With quasi-suspect, for the most part, the burden remains in the government and the presumption of liberty. So it's a lot closer to strict than it is to rational basis. I'll tell you that much. And the language is a little bit different. So what's the fit? The fit is substantially related. So just compare them. Rationally related, number one. Substantially related, number two. And then narrowly tailored, three. Substantially related requires a closer fit between the means and the ends. Not exactly perfect, but something closer. What they would later call a persuasive justification. So strict scrutiny is very hard to beat. Generally, strict scrutiny, what they call is fatal. Fatal. You're not going to win. Intermediate scrutiny, at least in theory, can be beat. You can satisfy it. Also, the interest must be not compelling, but important. What's the difference between compelling and important? I don't know. This is all just made up stuff, right? These are not meant to be bright lines. The only point is it's a little bit easier to satisfy this test. So what are the quasi-suspect classifications? For sure, it's sex. There were hints for many years that sexual orientation might be quasi-suspect, but Justice Kennedy doesn't really like scrutiny, so he just ignored it. There were attempts to make, for example, disability and other matters quasi-suspect. That never went anywhere. Even in this case, Scrimetti, is transgender status quasi-suspect? I don't know what the court's going to do. They're probably not, right? So I'm giving you all these tests that were really useful in the 1980s. You need to know them. They have almost no bearing on modern constitutional law. Just none. I mean, maybe the Supreme Court will bring it back in Scrimetti. I am skeptical. Maybe a little bit, but not really.
Do the other classifications in footnote 4 go for the due process clause for like the enumerated rights?
Kind of, right? So the three categories of footnote 4, if you recall. One is if something's in the Bill of Rights. That's kind of due process, but not really. It's just the Constitution itself. The second was what they call political process theory. That really comes into play with almost always racial discrimination, right? It's hard to separate denying political process theory to who issues to minorities. So in almost every case where there's a political process theory, it's race, right? There's a racial gerrymander or there's a deprivation of voting rights. So it's almost all race. So footnote 4 really boils down to race. You're not happy yet?
No, just because I was just thinking about that. That seems like productive.
It is. That's why footnote 4 has never been like this thing that has a salience to itself. It's kind of just like a guideline. Michael's your hand up?
No.
Okay.
Just thinking.
Okay, thinking. That's good. She'll think. I like thinking. All right, everyone good with 1, 2, and 3. All right, I'm going to scroll down a little bit. This is for later. This is for next week. When we're talking the due process clause, we also have scrutiny. It's a little bit simpler. Not really, but it's less stuff to remember. So under the due process clause, we again have rational basis and strict scrutiny. How do you distinguish them? How do you tell them apart? Laws that burden what they call a fundamental right. A fundamental right are afforded strict scrutiny. You review them very carefully. And with strict scrutiny, the burden's on the government. Everything else is a non-fundamental right. So laws that burden non-fundamental rights are considered subject to rational basis review. The burden's on the challenger. So what's a classic fundamental right? What's a classic non-fundamental right? The right of contract, Lochner, right? That's the easy one, right? Lochner is non-fundamental, rights of contract Under Lee Optical and Caroline Products, you're given only a rational basis scrutiny. That you know. What rights are fundamental? Marriage. That is Loving. Loving said marriage is a fundamental right. The court extended that in a case called a Bergefell, involves same-sex marriage. They more or less, that's a fundamental right. The right to sexual intimacy, that's considered a fundamental right. Maybe a few others. What about abortion? Where does abortion fit in? Well, it depends what year you're in. If you were to read Roe v. Wade in 1973, you would think that abortion is a fundamental right, which is subject to strict scrutiny. They don't say that, but that's, I think, the best reading of the case. Then if you go to 1991 with a case called Planned Parenthood versus Casey, the court sort of rewrote Roe. They said, no. We don't do strict scrutiny for abortion. We do something else. This thing in the middle called the undue burden standard. We'll do that one next week, right? It's basically like intermediate scrutiny for abortion. Like they just made up a thing. Same way they made up a thing for sex in the middle, they made up a thing for abortion in the middle. They just keep. You will find Justice Scalia has described basically there have been so many made up rules for abortion throughout constitutional law, in speech, in standing, everywhere else. Just like it's the body unto itself. But at least for between 1991 and 2022, good 30-year run, we had something called the undue burden standard. But after the Dobbs decision, no more abortions given rational basis review like any other unenumerated right. So really, you might ask Josh, are there actually more fundamental rights? The only ones that I can think have any salience in modern law are those that were recognized in Meyer against Nebraska, right? Rights of family, rights of procreation, rights of marriage. Those sorts of rights, maybe. But again, Justice Kennedy didn't like fundamental rights. So it just doesn't have much salience. This is all, again, scrutiny for substantive due process, and this is all scrutiny for equal protection. To Conrad's point of the Bill of Rights, the Bill of Rights is nowhere on here, right? They're all different tests for free speech and free religion. It's completely different, right? That's not on this chart at all. Taylor.
Was there a presumption or maybe a trend prior to Lochner?
I didn't hear the first one. What was before Lochner? The first one. I'm sorry.
Before Lochner, was there any sort of presumption or maybe a trend that was
Depends what you mean before Lochner, because before Lochner we had cases like Slaughterhouse, right, which rejected economic liberty rights. In candor, by the 1870s and 1880s, the court began flirting with having a presumption of liberty. At the same time, other people like James Bradley Thayer, a very prominent scholar, said, no, we have to have the restraint. We have to have deference to the government. It's called Thayerism, Thayer, Thayerism. So I don't like saying trends because at the same time, different people were saying different things. But you had definitely some people saying you have to have a more robust review of economic regulations. Other people said, no, we have to have deference, where the progressive movement was we should defer to the elected branches. Did I answer your question, Taylor?
Yes.
Thank you, ma'am. All right. Everyone get these, I guess, 6 bullets. If you don't, rewatch first half hour of this class. I'm putting a lot of time in today deliberately, so I have to do it later. Right, but I want to do it right now at this moment. So we'll do the questions. We got this one. Yeah, all right. I did the age question. I think I'll do these once again. All right. All right. Questions before we get started. All right. Let's move on then to affirmative action. I'm going to start this. Let's start like this. Who am I up to? Where am I? Okay. Let me ask you a question. Why did the schools in Kansas and in South Carolina and Virginia and other places impose racial segregation?
for the students.
Why?
Just because, like, well, for honestly, for violence purposes in a lot of places, or for to make sure that people are not like fighting in school.
All right. But I think the first thing, Sal, I'll just repeat. I think you said they thought it would be better for students to learn in a segregated
That's what
environment.
they said.
Oh, I know that's what they said. Do you think they thought that?
Depends on the person.
Okay. So, Trent, let me ask you a follow-up question. Why do you think the University of California, Davis imposed their affirmative action policy?
I think it was a mix of like trying to like almost like a form of like reparation, like historical reparation in a way.
So it's a mix. Historic reparations. What else is in the mix?
I think also it makes it just like you want to like kind of like advance people from like other backgrounds, like in a way that like gives them like like they said, like they want to like give people like options and opportunities that other people had. So that's like both like retroactive and proactive.
So I think I want to start actually by drawing a contrast between two dissents you read, or two partial dissents you read today. The first by Justice Thurgood Marshall in the Bakke case, and the second by Justice Clarence Thomas in the Michigan case. You could not get two people who disagree more about something. It's not possible. And their backgrounds, I think, both give them the right to say what they think. And let me just sort of sketch this out. Justice Thurgood Marshall, before he was on the court, was the most famous civil rights lawyer in the country, right? He argued the school desegregation cases, right? He argued Loving against Virginia, right? He was probably one of the most important lawyers of the 20th century. I'm not exaggerating by saying that. By the way, Ruth Ginsburg's on that list also. They both make the top 5. Justice Marshall was appointed to the Supreme Court as the first African-American justice. That was a moment of sort of celebration for the country. They think that go from, Brown was born in 1955 and barely a decade later of a black member of the court was a huge deal. And Justice Marshall, I think, articulated a philosophy. He said you can't look at the racial issue on a blank slate. That you can't say, okay, we got Brown, okay, we're done, we're good, right? We overruled Plessy, kind of, and we can just move forward. He describes 350 years of oppression, right? Going all the way back to the 1600s in this country. And he says that these modest efforts by the University of California to provide opportunities to people who may not have had them otherwise are not a problem. Indeed, he looks back further. He looks at Reconstruction. So I have you reading the Freedmen's Bureau Act, right? What did the Lincoln and Johnson and Grant administrations do towards the end of the Civil War and even after the Civil War? They created basically bureaucracies, these organizations that would provide land, animals, money, funding, education to the freedmen, to the freed slaves. And Thurgood Marshall says, look at this, right? How can you look at this history after the Civil War and see that we can't have a number of seats in the medical class set aside for Black as well as Hispanic and other minority groups? Right. There's a this is not sort of public, but it's public, but it wasn't like known to the public. But Justice William O. Douglas wrote his autobiography on the Bakke case. And during the discussion, they have their private conferences. And apparently then someone said, this is discrimination against a white guy, Bakke. And Thurgood Marshall, by the way, he was very funny. Apparently he had like these legendary jokes. I never met him. I never had the chance to meet him. He was alive when I was alive, but I never met him. But he had these good jokes. So apparently Someone said that this is discrimination against the white guy, Alan Bakke. Apparently, Thurgood Marshall turned around and said, "You guys have been practicing discrimination for years. Now it's our turn." Bit of a mic drop moment, right? Basically, like, shut up. In other words, this is not what we're discussing about. Okay, I can talk about the Thurgood Marshall dissent for an entire class, but I want to move on to Justice Thomas. Right? Justice Thomas, again, if you haven't read his biography, My Grandfather's Son, you should read it. It's a remarkable story. He grew up raised not by his parents, by his grandparents, in a dirt poor community in Pinpoint, Georgia. He barely spoke English. The primary dialect was Gullah. It was a dialect spoken in only parts of Georgia. He grew up with his brother, raised by his grandparents in poverty. And how he found his way is just sort of remarkable. He was always very bright, a lot of aptitude. He was very angry in his youth. He was very angry at the world. And he somehow found his way to the Catholic Church, and he wanted to become a priest at one point, and he decided against that. But he started off at Holy Cross College up in the Northeast. And this was during the 60s with Vietnam and the protests. He got really into the counterculture. And he's just very angry at the world. And the way he described it is he let the anger go. And he realized that he wasn't angry at the others, he was angry at himself. And he found a way to sort of cope with the world. He was admitted to Yale Law School. And he admits he was admitted because of affirmative action. He not only admits it, he regrets it. Because he said growing up, whenever someone saw him at Yale, I was like, "Oh, you got in for affirmative action." And the answer was he did, right? He was smart in his own right, but people assumed that he only got in because of a racial preference. In fact, Justice Thomas tells a story. He put a cigar sticker on his diploma because that's what it was worth, a few pennies. His Yale diploma, right? By the way, the judge today, Judge Hull, will not hire law clerks from Yale. He'll hire from South Texas. True story. Justice Thomas went hired from Yale for the longest time, eventually got over it. But he favors a notion of equality that's very different than that of Justice Marshall. If you ever go to Justice Thomas's chambers, he has a bust of Frederick Douglass in his office. And there's this quote I gave you from Frederick Douglass. It's in the opinion, and he basically says, what should you do for the black man? Is leave them alone. Don't do anything for us. Everything you do for us is harmful. So what's remarkable is that Thurgood Marshall had seen Brown as like the crowning achievement of his life. And Justice Thomas, I didn't assign that, but it's in a different dissent. Justice Thomas sees no difference between the segregationists in Brown and the DEI officials at Michigan. He sees no difference. That they're both using race to subjugate people, to see that you're lesser, so you need this boost. He made Justice Sotomayor very mad because Sotomayor, who was a newer member of the court, went to Yale, and she admits because of affirmative action, and she was proud of it. She said, "This gave me the chance I would have never had otherwise." By the way, her what's her biography called? I can't blank on the name. It's a very good book as well. Biography. No, not Juan Soto. It's my cool autocomplete. Okay. Right. So Justice Sotomayor's biography was also quite good. She tells her story. My Beloved World. I'm sorry. It's called My Beloved World. She tells her she grew up in basically the projects in New York City in the Bronx, right? Father was not present. Mother was not well off. And she found her way again through Catholic school. She got to college at Princeton and Yale for law school. She became a federal judge in her young 30s, maybe 33, 34. Who does that, right? And then she was appointed by President George H.W. Bush to the district court. And then Clinton put her in the Second Circuit. And then President Obama put her on the Supreme Court in 2009. So again, she has this other experience of how this affirmative action helped her immensely. So if you want to see how some very smart judges who from the poorest of the poor came to such a diametrically opposite perspective, go read Thomas and go read Sotomayor. It's sort of, I don't know. I think it's a very enriching experience to learn about these people. I don't agree with Sotomayor, but I think she has a very important story, and I'm sort of glad she's in the court. She tells that story we all can read. Yes, ma'am.
So I actually researched Justice Thomas after reading this, but I was wondering why he felt the way he did.
Yeah.
So why did he feel that way when he did get Indy out for affirmative action, and he probably wouldn't have become who he was if he didn't, you know.
Do you think that though?
Maybe.
Yeah,
I mean, Yale's a really good law school. And,
it's overrated.
well,
No, no, I'm mostly.
When he did it was very good.
No, I'm mostly joking. So I'll respond to you again. Justice Thomas isn't here, and actually, ask Judge Ho about this. I'll ask Judge Ho about this. Right, Judge Ho. We'll talk about in an hour or so. He was also an immigrant. He came from Taiwan as a young child. He clerked for two judges who have been very critical of affirmative action. The first was Judge Jerry Smith. And Judge Smith was one of the judges who declared the UT affirmative action policy unconstitutional in the 1990s in the Hopwood case. And then later, Judge Ho clerked for Justice Thomas in the Supreme Court. So you can ask or ask him myself, if you will. But I think what Thomas would say, and I don't want to speak for him, but I think he would say is, I feel cheated. In other words, maybe I could have achieved these great things or something else, but no one will believe me because of this policy. You know.
Do you have any examples of children from affluent Black families that?
Ketanji Brown Jackson.
I'm sorry?
Ketanji Brown Jackson.
Okay.
She was a very, I mean, she went to the same high school as Jeff Bezos, very wealthy high school in Miami. Yeah. I think her father was a lawyer. Just check me. I think one of her parents was a lawyer. She and her husband is really wealthy. He's actually a doctor in DC, and
White.
he is.
Yes.
Yeah, he's a very extremely wealthy doctor. So she did not have the same story that Justice Sotomayor or Thomas would have had.
Right. I guess I was going to say, would you argue that the time that those things were still, before the Harvard decision and everything, that affirmative action could still benefit people if they would have qualified regardless? That they would open up a spot.
So it's interesting, and I don't teach a case anymore. It's still in your book. It's called the Fisher case from University of Texas, so actually much more closer to home. UT argued that we don't just want poor minorities; we want wealthy minorities too. Is that we want the kid who's the father of the Black doctor in Dallas, right? They would actually put this in the record. So it wasn't solely about socioeconomic. It was also, I mean, we can talk about this later, but it was beyond just race. They wanted Black people of all different economic strata, if you will. Yeah. But Justice Jackson, again, she also is very quite proud of the fact that she, well, actually, I shouldn't say that. I don't know if she's actually spoken about this. By the way, do you know who Justice Jackson's classmate was? Professor Rutledge. They went to Harvard together.
Really?
Yeah, they were classmates. They were friends, yeah. Go ask her about sometime. Yeah, and anyone might have a classmate goes to the Supreme Court one day. Who knows? Anna?
Why do you not teach Fisher 1 and Fisher 2?
Because of the Harvard case.
Okay.
I dropped it because it doesn't matter anymore. The court basically overruled it.
Oh.
In fact, I don't think I'll be teaching the Michigan cases next year either. I took probably the last rock because it's in the book, but I'm probably going to drop it also. One of the weird parts of this class is that every time I teach, I have to add and subtract cases. Randy and I are going through the final phases of making the 5th edition of the book. So you're the last ones to use this edition. Congratulations. It's a collector's item, which you'll never use ever again. I'll be in a bookshelf collecting dust. But the Fisher case actually arose from here. Abby Fisher was from Sugar Land. In fact, one of my students years ago was actually her classmate. She went to LSU, apparently not as good as UT, I got to know. But she went to Sugar Land High School. It's funny, there was actually another plaintiff in that case. I don't remember her name, but she dropped out of the case. Why? She went to SMU for law school. Did not want to be a plaintiff as a law student. Imagine being a law student with your case at the Supreme Court while you're there. It's like, so, hi, it's me. So actually the case became Fisher. It was another girl. I can't remember her name. All right. Yes, sir.
I have a question on like the Bakke versus Justice Thomas, and the strict scrutiny, where he argues essentially that there really is no legitimate correlation between diversity of class and the outcomes, the proof of outcomes that they presented, but it's just racial, like assuming that the presence of race in the classroom will affect educational outcomes. But that doesn't seem like it's intimately connected to anything because they had no real proof. It was just like an assumption.
I'm going to answer your question. I want to walk through the cases.
Oh.
I promise to answer your question when I walk through the cases. but I'd just like to start off with the and we'll come back to this because I think Sotomayor and Jackson, Thomas and Jackson have some back and forth in the Harvard case for our next class. What's fascinating though is that even though they disagree, they're all good friends, and I do mean that. They get along quite well. Justice Thomas, his reputation, he's the nicest man in the building. He knows the name of every employee in the building, even the guy who runs the elevator, the people in the cafeteria. He knows, how's your grandson doing? He just knows everything. It's kind of this juxtaposition. It's like, it's like, this big guy that's just opinion is so harsh, but he's very, very nice in person. And I found Justice Jackson extremely pleasant. I only met her once, and she sent me a very nice note about something. So I have just only good impressions of her. Sotomayor, I always send a copy of my books to the justices, and she mails them back. Because she says, this is about a pending case. I can't accept your submission. So the 8 justices send, thanks, Josh. And Sotomayor returns a book to me. So government postage ways, she should just thrown it out. She didn't have to mail it back. I don't know. It's not mean. It's her policy. In fairness, she's consistent. She's mailed back several of my items. I keep saying to her as a courtesy, even though knowing she'll return it. But she says the policy she sticks to. All right. Can we start about Bakke? Yes, ma'am. You're next. Oh, you're volunteering.
No, I know.
Okay. Yeah, what are the facts in Bakke? Go ahead, please.
The UC Davis Medical School had a special admission program designed to increase enrollment of minority and disadvantaged students. And they're using a separate admissions process and reserved like 16 out of 100 seats in each class to have minority applicants. And then applicants in the special program weren't required to meet the same academic cutoff like GPA and scores. And then in Alan Bakke, a white applicant applied in 1973, and his scores and his GPA were higher than those in the special program, but he was rejected. And then he
Okay, good. Okay. So there were several affirmative action cases in this period. And I'll tell you something. The Supreme Court did not want to decide it. There was another case, it's actually in your book, I don't assign it, called Defunis, Defunis. And this was an affirmative action case. I think it was from Oregon, if memory serves. I might be wrong on that. And here's what happened. You had an undergraduate person who challenged a policy. And by the time the case gets to the Supreme Court, he graduated. And the Supreme Court said, never mind, it's moot. I hate when they do that, right? It takes like 4 years to decide a case. And like, never mind, the case is moot. You're out of college. We can't actually help you anymore. So the case is dismissed. That's actually a very important case for standing. So why is the Harvard case called Students of Fair Admission? To avoid mootness. It was an organization of people who would always be in the organization, so they always would be standing. Abigail Fisher actually graduated from undergraduate by the time the case came to her. But what was her basis for an injury? Her application fee. She was seeking a refund of her application fee. It's a dollar amount, the injury. In fact, UT, some lawyer said, we could just refund her application and get rid of this case, but they just wanted to decide the case. You'll actually one day deal with what's called standing, right? How do you actually get into federal court? You have to have some injury. And there are all these ways the court can avoid deciding cases. So at least in the Bakke case, the court went ahead and decided the case. He still had not graduated from medical school. They could still at least admit him. In fact, he was admitted and graduated some years later. Okay. So the policy at the University of California, Davis Medical School was what you call a set aside or a quota. There were a specific number of seats that were reserved for specific racial minorities. Okay. What is that? Good voice. And it applied to Blacks, Chicanos, basically Hispanics, Asians, and American Indians. Okay. There were roughly 16 seats set aside. Alan Bakke, a white man, was not able to obtain one of these seats, and in fact, he was denied several times. He contends that if the seats were all open to people of all races, he would have been admitted. Okay. The split in this case was confusing and complicated. So again, at the time, there were 9 members of the court. Justice Lewis Powell was what you might call the swing vote, the moderate. Okay, he was in the middle. So it's not terribly important, but it's good to know. What happens in the Supreme Court when there's no 5-member majority? You have these 2 blocks of 4. What is the holding of the case? This will be counterintuitive. When there's not a single 5-member block on the court, the holding is the narrowest position. Which position is most narrow? So get this, guys. A single narrow vote can trump 4 broader votes. Yeah. I told you I'd blow your mind. It's a weird rule in the court when there's not a single 5-member majority. The most narrow position is the holding. They say, Josh, what's the most narrow position? Who the hell knows, right? This is a test that's incoherent, beyond incoherence. It's often called the Marx rule, M-A-R-C-K-S, the Marx rule. Not like Karl Marx, but Marx. Might as well be, right? So what happens in the Bakke case is you have these 2 blocks of 4. So over here, the court's liberals, right? You have Brennan, White, Marshall, and Blackmun, no relation, right? They said, this is okay, right? Affirmative action doesn't violate the 14th Amendment. Affirmative action does not violate the what's called Title VI. Title VI is actually important now. It's a federal statute that bars discrimination for schools that accept federal money, which is basically every school, right? That's actually the basis of why we, as South Texas, a private school, are subject to the Harvard ruling. So affirmative action did not violate anything. So 4 members of the court were withheld everything. Then you have, I don't call them conservatives because they're not, but the 4 more conservative members. You had Chief Justice Berger, Potter Stewart, William Rehnquist was cyber. He was rocking it in the 70s, right? And then John Paul Stevens, who became a liberal, but at least then he was still kind of conservative. Okay. The 4 conservatives said they did not reach the constitutional question, but they said that the affirmative action policy violates the statute. All right. So then you have Justice Lewis Powell in the middle. This would drive law students crazy for decades, 25 years. And Justice Powell said that the Davis policy was unconstitutional. He was the only one who said that, right? He was the one member of the court who said it was unconstitutional. The others only reached a statute. But he had this other opinion, and he said, well, the way Davis did it's no good, but look at Harvard. Look what Harvard's doing. They're doing it differently. They're not using a quota. They're not using race as one of many factors. They're using race as a plus factor. That is, you review the entire application holistically. And when race is used as one of many factors, that is permissible. Again, the Harvard case wasn't present here. Why was he even talking about Harvard? This was about UC Davis. Because Justice Powell was an old school swing vote. He was a moderate. He said, look, I'm going to rule for the challenger here, but I want to tell you there's a way to do it better. Right? He's decided some other issue. It's not present. And he said, just one member of the court approved Harvard. What about the 4 conservatives? Did they approve the Harvard plan? No, they didn't. They didn't say a word about it. So the effect of the Bakke program was to leave a state of uncertainty for decades. In fact, that's how Texas declared unconstitutional the UT policy. By the way, why does Texas have a top 10% plan? The top 3% now? 6, yeah, it varies year to year, but it's called top 10%. Where if you graduate in the top X percent of your class, you're guaranteed admission to the state schools. Why? We have that here because the Fifth Circuit declared Texas's policy unconstitutional in the 90s in a case called Hopwood. But what's the dirty secret of the top 10% plan? It's affirmative action because neighborhoods are racially segregated, right? We have all black high schools and all Hispanic high schools. If you take top 10% of all these high schools, you're going to get something close to an affirmative action policy. So Justice Ginsburg made this point of dissent to Fisher, like, let's just be honest. Let's just call it affirmative action. Don't call it this 10% plan. Actually, a professor at UH, is Michael Olivas, he died a few years ago. He wrote it. He was very admitted. He's like, this is getting around Hopwood. And it did for the most part. I actually don't teach Fisher because it's a 10% plan. It doesn't really work anymore. Okay. But Bakke created this uncertainty where it wasn't really clear what the state of the law was. Okay. Now, what's important also, Justice Powell's decision thinks about what is the compelling interest, right? What is the compelling interest for affirmative action? Now, who said reparations? Was that Trent? Was that your comment? Right. So Trent gave an answer. I think most of us would probably agree, right, that the primary justification for affirmative action, at least with regard to African Americans, is there's been some past stuff done that was bad, and that this will work to remedy or repair or reparations those past wrongs. Justice Marshall makes his pointing very well in his separate opinion. But what does Justice Powell say, a Virginian? He says, no, that's not a compelling interest here. In other words, there's no evidence that UC Davis engaged in sort of discrimination, so they're not repairing their own bad acts. And you can't treat general discrimination as a compelling interest. It has to be tied to that institution. So there are other cases where you have a school district that discriminates, they're allowed to use race to remedy their own past actions. But general societal discrimination is not enough. So the court rejects any sort of reparation theory of affirmative action. Instead, what is the only rational basis? I'm sorry, what's the only compelling interest that is being used? Angelica, what interest is being used?
I don't know how to explain it, but like Justice Thomas said, leaving him alone versus.
No. Justice Bakke, let's just focus on Powell for a minute. What does Justice Powell say is a compelling interest that can justify affirmative action? There's only one he upholds. He rejects them all except for one. This is important. Juliana?
He said obtaining the education benefits that flow from an ethnically diverse student body could support it.
Very good. Okay. This is important. The only compelling interest, like we go back to strict scrutiny, right? What's required? A compelling interest. The only compelling interest to justify racial classification, justify affirmative action, are the benefits, the educational benefits that flow from affirmative action, from having a diverse class. Are the educational benefits that flow from having a diverse class. Do you understand that? That's it. Now, a few minutes ago, Shelton said, well, what are those benefits, right? Well, how do you quantify those? Justice Powell didn't even bother. He didn't even try. So an issue becomes, do you defer to the university? Does the university get to decide what those benefits are? Well, then who says it's compelling? Is it the court or the government, right? Now, let me just pause on this for a moment. The thinking is that having people with different racial backgrounds will affect the sorts of classroom discussions or campus interactions. Justice Thomas says in response to this, doesn't this just tokenize students, make them token to say specific things? What if a student just wants an education, doesn't want to be a spokesperson for a specific kind of race? What's sort of almost demeaning about Powell is he says, we're letting you here because you can help other people, right? It's not we're letting you here because we want to help you. It's we think you can say nice things in class. We're letting you here for that reason, right? Even advocates of DEI and affirmative action hated the Powell opinion, right? They said this is disparaging. That the reason why we're being let in this classroom is just so we can help out the white kids learn more. Is that why we're here? So it's almost the worst possible rationale for affirmative action you have, but that's what's allowed for 25 years. So what ended up happening is everything became about promoting diversity. Why do we have DEI? It's Powell, right? This Virginian, right? Who said this in 1978, right? It's we have, well, how can we learn more from diversity? Everything became a byproduct of having people of diverse backgrounds teaching things. It's all because of this opinion, which created this elaborate song and dance for years of how we can justify these policies under this rubric of diversity. Right? That was the basis. It was never really about helping people. Let me have one flip side. Let's say the court had adopted an argument that affirmative action can be used to help people, to restore them to a certain place in society based on past discrimination. What's the limit? What's the stopping point? At some point, we don't need this anymore. This is the 25-year clock in Grutter and Gratz. The perhaps one saving grace of the diversity approach is it will always be present, that there will always be the need for these educational benefits, and it'll ongo forever. By contrast, if it's about repairing past discrimination, at some point, it's no longer going to be needed. Okay. Justice Powell also says that there's no form of benign discrimination. What do you mean by benign? So Justice Stevens described it this way. It's a difference between a welcome mat and a no trespassing sign. In other words, the affirmative action policy using race to help people, whereas Brown of the schools using to harm people. Justice Powell rejects that there's no benign use of race. All use of race is sort of sorted, but it's only permitted in the limited context of these educational diversity benefits. Okay, everyone with me? Questions on the Powell opinion? Yes, Stephen?
So like, going back to like the domestic classification for race, you said like there were two types of conforming interests. One was national security for Matsu, and then this is the second one.
Yeah, that were upheld. Yeah, at least from my recollection, the Supreme Court's upheld two racial classifications. First in Korematsu, second in Bakke, and Grutter and Gratz. Those are the two. Yes?
It seems like the logical flow of Justice Powell is like he ends up classifying by race by arguing if you have certain races in the room, you'll get certain perspectives that will be helpful, which means certain races have certain perspectives, classifying perspectives based on race. And it seems like that should be subject to scrutiny, like the whole idea.
It's a presumption, and I'll try and say this carefully, maybe I'll fail, that they presume that a person from a certain racial background will say certain things in a class or certain perspectives. That's not a guarantee, right? I think, and I can say this, I've been teaching now for almost 15 years. Students surprise me all the time. I don't know where you all come from. I have just no idea. Maybe you talk to me, tell me. You are all very interesting people. I mean that sincerely. You have just very different lives. And sometimes I hear someone's like, wow, I never thought about that. The presumption of the Bakke opinion is that people who look a certain way will say certain things, and they should admit it for that purpose. It might be true. It might not be true. But that's the presumption. And saying that this racial classification is permitted because these benefits are so great. Okay. The other issue, sorry, there's a hand here, I'm sorry. Yeah, Bobby.
So would you say this is welfare or morals? Because it seems like now we're adding education into police power.
Yeah, I'm not really sure which one would fit in, the welfare or morals, maybe, I'm not sure. But I want to go back now to this test, right? We talked about the compelling interest, but what about the tailoring? The tailoring has to do with how much race is being used. Why does the UT policy fail? I'm sorry, the UT. Why does the UC policy fail? Because it's a straight up quota, right? It limits seats people of race based on their race. By contrast, he says the Harvard policy is more narrowly tailored because race is one of many factors considered in an application. So again, the two elements, there's the narrow tailoring and the interest. They uphold the only interest is the compelling interest of educational benefits from diversity and whatever. Narrow tailoring is you have to use race as one of many factors. That's how Powell reconciles his opinion with strict scrutiny. You want to see that?
So I was gonna say, if you would like to break this case down, like just like one paragraph, like without all the other stuff, basically you said they found the interest, but the means are not nearly tailored enough, right?
Yeah, that's a good summary of the case. The court found that UC had a compelling interest. There were educational benefits from diversity. It wasn't that we need to repair past discriminations. It wasn't that we need more doctors from underprivileged communities. It wasn't that we give opportunities to those who couldn't get. All those were rejected. The only interest was having more Black, Chicano, and Native American Asian students will help learn more about medicine or something like that, right? They don't really explain what that means. Every other base, which I think we would all agree have some salience to them, rejected. But where the court failed the UC policy was on the narrow tailoring, that the use of race was too heavy because it was a straight up quota. They have to balance it among many other factors. Yeah.
It kind of seems that in Bollinger, what they did in the Obama case, where they like cut out pieces to make it work however they want. It kind of seems that Powell did that in this case. I don't know.
Oh, the Obamacare case, you're drawing it out. Yeah, you know what? Swing votes in the Supreme Court have a tendency to do that. They don't want to rule too far to the right, and they don't want to rule too far to the left. So what do? They go somewhere in the middle. And they sort of say, well, you can't do this, but you can do that. In other words, Justice Powell, writing for one member, upheld a policy that was not even present, that no one even litigated. And then it was, okay, let's just follow that one vote. It's a weird part of the Supreme Court. For the longest time, Justice Kennedy was a swing vote. Justice O'Connor was a swing vote. And our current court is probably Justice Barrett in any given case. She's sort of somewhere in the middle. Stephen?
So like, are we just doing like putting it into like a two-step test, I guess, with like the interest in error, so really not three?
1 and 2 probably merge. I think you ask, what is the means? The means is the quota, right? Is the quota a narrowly tailored way of achieving the interest? In this case, the answer is no. So 1 and 2 probably merge. There might be some cases where they're separate, right? There might be some case where the means are so, irrational, where it doesn't even work. Imagine the school says we're going to just, admit people based on flipping a coin or something. That might be completely irrational. Yes.
If they had come up with an idea about like let's base the number of positions open to minorities or whatever social group based on like percentage of the population in the state, if that's how they decided to go.
Well, that's also a quota, though, right? Because let's just say I'm making up. Let's say they're 15% African American, say 20% Hispanic. That's a straight up quota. To be sure, it's based on arbitrary numbers. It's based on the population of the state, but it's still be a quota.
So even if it's based on like the percentage of the population,
yeah,
I get it's still like a quota,
but you're still sure, but you're still guaranteeing seats to people based on their race. I don't think that would work into the Bakke opinion. Yeah.
I kind of want to follow up. So is there no enumerated list of compelling state interests?
Nope, all made up.
Okay.
All made up. And again, Justice Thomas makes this point in his dissent in the Michigan case. He said, can it really be that the only compelling interests are Korematsu and Grutter and Bakke? Can that really be the answer? The court's not in a very good position to decide what interests are compelling, right? That's something that really the government should decide. In fact, Justice Scalia, in the religious context, said that we should not be deciding what's compelling. That's not for us to decide, it's for the government to decide. Who are we to say that, oh, no, that's not compelling enough for the government? All right, questions on the UC case? Alan Bakke. Where is he? He eventually did graduate from UC. Eventually he got in. I think I picture him somewhere. I don't have a picture of him anyway. All right, that's Justice Powell. Okay. All right, let's go on to Michigan. I was actually just there a few weeks ago. The admissions office is a few blocks from the law school. Taylor, I think you're next. All right, so just so we get the facts straight, there are two Michigan cases. Grutter, Grutter, was about the law school. Gratz, Gartz, Gratz was about the undergraduate institution. Okay? The difference matters because one policy was constitutional, another policy was declared to be unconstitutional. So I actually want to do them in reverse. Let's do the undergraduate first. So that's Gratz, if you will. I probably will never teach this case ever again, so my last hurrah. It's okay. One of the fun parts of this job is there are always going to be new cases to teach. It's always a sort of evolving class. Torts, it's the same thing every year. Property, it's the same thing as the time Henry VIII. It's the same thing. This one's always new. I don't think I won't be teaching common law next year, my friends. I'm sorry. I'll be teaching in the fall Supreme Court seminar, which I encourage you to sign up for quickly. It fills up only 11 people. It's a lot of fun. You can take that in the fall. But I'm not teaching. I'll be on sabbatical in the spring, so I'll not have any classroom in the spring. So, and have you again, but good having you. Okay. All right, Taylor. So give me the facts, please, about the undergraduate affirmative action policy at University of Michigan.
So there were two students. They were both white. They were both denied admissions to the undergraduate school. And their admissions decisions were based on multiple factors. One of them was race. The university admitted almost all applicants of certain races being underrepresented if the applicants met academic qualifications. And then in 1998, the university adopted a point-based admission system. Different point values were assigned to different factors.
Yeah.
An applicant could score up to 150 points, but they needed 100 points to be required, or 100 points were required for admission. And if an applicant was a member of an underrepresented minority, they were automatically given 20 points, which was one-fifth of the required 100. Gratz and Amy they filed a class action suit against the university and certain individuals. And they said that it violated the admissions policy, violated 14th Amendment's equal protections clause, and certain civil rights statutes.
Okay, very good. Thank you so much. All right, so you are all, relatively closer to having your SAT score. So these were actually so the judge I clerked for on the Sixth Circuit was actually involved in this case many years ago. So he had very detailed records, which he sent me. But the way the undergraduate used race was extremely overt. And just to give you a sense, so let's say your SAT score was between 1200 and 1290, and you basically had a B- GPA. If you were white, your chance of getting in were at 12%. If minority, 100%. If your SAT was between 1100, 1190, the non-minority rate was 11%, minority was 100%. Between 900 and 990, non-minority was 70%, minority 92%. So you got basically a 900 SAT score, and the rate of admission was 90%. Going up a bit, 900 SAT, B+ GPA, almost 98%. And if you had an A- GPA, 12%, 100%. So basically, they were admitting almost all the African-American applicants. There's just no way around it, right? The undergraduate was straight up mechanical. So if you remember, there was this formula where they had up to 150 points. 100-point guarantees your admission. If you were a certain minority, you got basically 20 points off the bat. There's this one line in the opinion, which I always sort of chuckle at, but you could be an artist like Monet, and that gets 5 points, right? What happens in the undergraduate case is the court splits 5-4. Okay, actually, it was 6-3. I'm sorry. And Justice Breyer's vote here is important. In the undergraduate case, the court says that this mechanical use of points, that this mechanical use of points runs afoul of Justice Powell's opinion in Bakke. Why is it significant? The court adopted Powell. Powell is just one member of the court, but the court elevated that to the holding of the court. So what did Justice O'Connor say? I'm sorry, what did actually Rehnquist wrote the opinion? Rehnquist wrote the opinion in Gratz, and he said this mechanical approach makes race the decisive factor for almost every applicant. The vote in Gratz was 6-3, and Justice O'Connor joined the majority, as did Justice Breyer. What's significant is that in the other case, Grutter, it went 5-4 the other way, where O'Connor voted to uphold the university's law school policy, and Breyer joined. Okay. I was actually in college when this case was decided. I remember, I didn't really follow attention to the Supreme Court, but I remember reading about the time. That was considered a very big deal. Justice Ginsburg dissented in Gratz. I don't think it's in your book. But she made a point that would prove to actually be quite accurate. Ginsburg was very smart. She often was in dissent because of how the court was structured, but she knew what was going on. And she says, look, if we tell the universities you can do this but not that, they're going to do the thing that you're allowed to do. They're going to follow the law school policy. But what will end up happening is, she said, they will use winks, nods, and disguises. Schools will pretend to be doing the race is one of many factors, but in reality, they'll be doing the same thing they were doing before. They'll just call it differently. And she says, if honesty is the best policy, we should let Michigan just do what they're doing straight up and not have these sort of hidden things. Ginsburg said the same thing about 10% plan. She said, look, we should just be honest. If we look at the neighborhoods in Texas and how people move around and where they live, the 10% plan is affirmative action by another name. Let's be honest about it. I think she's actually right about that point. All right. So we're going to get Gratz. That's actually the much easier one. Grutter is the harder one. Okay. In Grutter, the vote was 5-4. Okay. What am I up to? Alexandra. Why? Can you tell me, how does the how does the law school policy operate?
So they had like an unofficial policy that sought to achieve student body diversity, where they gave substantial weight to the race of each applicant when they made admissions decisions, but they also, in addition, considered other academic and non-academic variables.
Okay. How, Alexandra, let me ask you the follow-up, please. How did the law school consider race? Or at least how they described it, they did it.
They consider it as a plus among many other factors.
What does that mean, a plus of many other factors? What does that actually mean?
So, I see it as like a boost or like something that would make the application more favorable towards admission.
How does it actually work, though?
Well, the law school can use it as a way to, the law school would give like consideration to all the way besides race. An applicant might contribute to.
How much weight was given to race by the law school? Do we actually know? No, we have no idea. Right? The law school, by the way, was smarter, and no surprise, bunch of law professors for anything, right? But the law school said, look, we have what they call holistic review. Holistic. What does holistic mean?
It takes into consideration like all aspects.
All aspects. Okay. And race is plus factor, one of many factors. How exactly do these race? Do we know?
No, it's holistic.
Okay. Ryan, let me ask you a question. How much diversity will be needed? In other words, how do they know when they've used enough race? What are they trying to achieve? Critical mass. What a great phrase. What does that mean, critical mass? Did they ever define what critical mass is? They never would, by the way. Even in the Fisher case, the Texas case, would never say what critical mass is. So this is why I actually like the Ginsburg dissent. Maybe I should include it more. So we have these phrases. We have to have a holistic review. We review the entire application. Race is one of many factors. And we're trying to achieve a critical mass of minority students. We won't tell you what those factors are. We won't tell you when we've achieved that critical mass. The university says, trust us. This gets the issue of deference. Yes, ma'am.
This is actually something I saw, this is Google related, but I know that they mentioned that maybe the next court case on this type of topic would be like alumni relations and like.
Oh, yeah.
Because it's also included on, or, you know, your parents, donors and stuff like that. What would you say, are there any cases on that yet?
So the issue is about legacy, right? So what's legacy? Legacy is, did your father go to the school? Will you be admitted as well? And necessarily, as a matter of history, that will favor people who are not minorities. That's just an aspect of history. The other issue that complicates is legacies are often people who donate money. So if your father offers to make a substantial donation to the school, will you be admitted? Let's go back to our scrutiny tiers, Marilyn. Does that trigger any sort of scrutiny? Probably not, right? I mean, the only argument that you might raise is by definition, having a legacy policy might disproportionately impact certain races. But the court hasn't really gone down that road of sort of disproportional impact. So there's not really a constitutional argument against legacy admissions, although in the wake of the Harvard decision, schools have tried to find different ways to increase minority numbers. And one way is to ban legacy admissions. I am skeptical that they're actually doing it. I am skeptical. They might say they're doing it, and they might just have other ways. And maybe I'm a cynic. I don't know. But if you ever walk around a college campus, look at those names on buildings, right? Right? This building. Well, I actually don't know if people donate money to this building have their kids who come here. Although I had Augusto's son a couple of years ago. He got in. He was very smart. So he was a very bright kid. Yeah. I don't think there's a legal challenge. I think it's a policy challenge to it. But I want to focus on this point. Again, they say, we will do a holistic review. We will use race as one of many factors. We won't tell you how we're doing it. And we're trying to achieve a critical mass. And we won't tell you when we achieve that critical mass. So the issue is one of deference. Trust us. So go back to our scrutiny, right? Who bears the burden to justify racial classification? It's the government. But this Thomas makes this point, he's very upset about this, the very nature of this approach is one of deference, where the court defers to the educational institution to decide how best to structure their policies and how best to decide when there's a critical mass. The dirty secret, and this was not actually a secret, is that they never intended to actually reach that critical mass. There was never actually a number they had in mind. They would never actually say, here's our goal. Why? Well, they said, we want to achieve a goal of 25% minority students. What do you call that? Quota, which run afoul of Bakke. So it's like this tension. It's like, we want a critical mass, but we won't tell you the actual number. It's like a circle, right? You can't escape the trap. By the way, if you notice, the Michigan policy was African Americans, Hispanics, and Native Americans. One Asian group, for a speaker today, was not on that group, which is Asian Americans. They are not considered underrepresented minorities in law schools because they're considered overrepresented in many regards. And if you look at other places, they basically exclude them as well. In the Harvard decision from 2 terms ago, Gorsuch goes off on this one very hard. And he explains that this is sort of gives away the game, that they're not really worried about percentage of population, they're worried about just other sorts of factors. We're only 70 years from Korematsu. Right? We're not that far from Korematsu as well. Okay. We want to talk about. Okay, so again, the court reaffirms Powell, reaffirms the Bakke test, and they go, what is the justification? The only justification are the educational benefits that flow from a diverse student body. That's the only benefit interest they seek. Okay, and they defer to the law school's judgment about how much diversity is essential to obtain those benefits. Bear with me. A very influential brief, a brief that was put in this case, was involving the military academies. A number of generals, other admirals, put in briefs saying that if the service academies cannot use affirmative action, that we will not have a diverse military. Because keep in mind, if the court were to rule that you can't have affirmative action, that could impact service academies. They said we cannot have a diverse military if we don't have affirmative action in admission for officer corps. This apparently was very persuasive to Justice O'Connor. She apparently was very troubled by this point. And they said we need to have a qualified diverse officer corps to have a more effective military. Fast forward to the present day, and basically all the military service academies saying we're dropping their affirmative action policies. So as a consequence of the Harvard case, actually it's not. The Harvard case said we're not talking about military. It's everyone else but the military. But the administration currently said we are not going to have any sort of DEI for our service academy. So we're going to see how that shakes out. There was litigation going on for years. The lower courts upheld against West Point and the military academy and the Naval Academy as well. Okay. Everyone with me? All right. Then we get to narrow tailoring, right? The reason why the law school's policy was upheld is that race was used as one of many factors, the plus factor, right? There was no quota. There was no set aside. How exactly race was used, we won't tell you. But it was used as one of many factors. So therefore, there was narrow tailoring. By contrast, the undergraduate was a set number of points. Yes, ma'am.
So if they pulled the admission status and saw like over a trend over the years of certain percentages, would that have supported that this is indeed what was outlawed by Bakke?
Can I answer your question? Mm-hmm. Do you think the university would ever disclose that information? They fought it tooth and nail. They used to release those statistics in the early 1990s and they stopped. Schools guarded this with their lives. You'll see this in the Harvard case, about what percentage of people were admitted with different types of grades. They did not want the information to be released. The Harvard case, they actually had a full trial at Harvard and UNC. They got this information, but Michigan did not want to release it. So what's interesting about our law school, and I mean this sincerely, we even before Harvard, we never had to use affirmative action. We didn't have to. For non-obvious reason, Houston is a pretty diverse city. We draw from a city where people are pre-represented. We never do much to actually help people get in. I won't say they never used it, because I know they did. I was in the admission committee once, only once. I more or less resigned because I said, you're breaking the law. They never let me back on. I was like, this is illegal. I was like, I can't do this anymore. But for the most part, we never had to. It happened a little bit, but it wasn't an overt policy. For other schools drawing from non-diverse communities, they would use it at a much higher grade, right? So it's interesting. Michigan is not like Texas. Texas at least had a history of discrimination, right? UT was literally a discriminated law school. Michigan, that was an abolitionist state. They didn't have slavery, right? They didn't have segregated institutions, so they didn't have the same sort of stigma that Texas had in official litigation. Harvard had discrimination against other groups. You'll see that against the Jews as well. They didn't let Jews in. They actually had Harvard had Jewish quotas for much of the 20th century. So go figure. Yeah, so
it seems that the quota system is actually more narrowly tailored. But I was kind of confused in the first one. I was hoping I got some clarity. Is it me or like it seems like the quota system is more narrow?
How do you see quotas as more narrow? Just walk me through that, please.
Well, it's in this case they created a number system that gives a certain amount of points.
Well, that's undergraduate.
I'm sorry, in the undergraduate, and having a core system using race for this particular reason to accomplish
Correct.
a particular goal versus an undefined goal for an undefined amount of people. Right? It seems like
It's more honest, right? The quota system is more honest. So again, this is sort of going into the weeds, but even though Michigan didn't have any quotas, they had goals and they had expectations. This came up a lot in the Harvard case where they had these emails sent around every few weeks saying, here's the number of minority students we have admitted so far. Let's keep going, right? It was just this, Ginsburg said this wink and a nod where they didn't say it, but they all said the same thing. And I've seen this stuff at schools as well. You say a thing without saying it. That's why they don't let me on committees. I always dissent from everything. I'm like, just I dissent from everything. I dissent. Yeah, go on.
I don't understand the deference standard for the university in these cases. Because I accidentally did watch the video for
Fisher?
Fisher.
Yeah.
And they
That
said
changed a little bit, didn't it?
Yeah.
Yeah. So at least in Justice O'Connor's mind, in the Michigan case, she says, we will not defer to the university about what their critical mass is, right? We will not defer of what their plus factor is, but she did. Fisher said more expressly, at least Fisher too, we will defer. So it almost inverts your rule where the burden is placed on the government. Here, it becomes a burden of the student to say why the policy is unlawful. It's almost like this carve out to strict scrutiny, right? Think of about the Harvard case, right? Maybe you like it, maybe you don't. But Grutter and Gratz never fit within strict scrutiny. Right? It didn't. It couldn't. That's not how strict scrutiny ever worked. That's not a compelling interest. That's not how tailoring works, and the burden's placed in the wrong party. So, I plan to have Robert's opinion next week. I'm not a criticism of it, but at least at a minimum, it sort of removes that carve out. Indeed, in back-to-back years, the court decides the Harvard case and Dobbs, they basically cut out undue burden standard, and they basically removed affirmative action from this strict scrutiny standard. They're basically eliminating the outliers that sort of never fit in. These are things created in the 70s to sort of deal with societal issues that didn't really fit into the doctrine. Did that answer your question or no?
A little bit.
Okay. The court then says at the end, Justice O'Connor's opinion, 25 years, right? Bakke was 78, Grutter 2003, so it's 25 years. And she says, maybe in 25 years, we won't need this anymore. Do you think she really thought that one through? I mean, she died about 2 years ago. She knew she'd be probably close to 100 in 25 years. I'm not going to be, whatever. It's not going to be my problem. Right? Someone else will deal with this. But in the Fisher case, I actually mentioned Justice Scalia actually said, well, we're almost at 25 years. What happens? We get rid of it now? Can we get rid of it a few years? People actually argued, not yet. We're still 4 years short of 25 years in the Harvard case. Not that it mattered. Okay. Okay, so any questions of the majority, Justice O'Connor's majority in the law school case? Ms. Bobby?
Do you think this could have been a right to education due process issue as well?
Let me flip that on you. There are many law schools in Michigan, aren't there? You ever heard of Wayne State? Never heard of it. It's a public school in Detroit. Their admission standards are much lower. If you want a legal education in Michigan, you have options. Now, the better question is the government. Must the government have a law school? Maybe, maybe not. Must the government have an elite law school? Thomas says no. Here's another dirty secret. If Michigan wanted to increase their racial minority numbers, what could they do?
Just change their standards, like make them the same for everybody, I guess.
They can drop the LSAT requirement, which many schools considering now. Some have actually done. Wow, yeah. In other words, if it's the case that these standardized admission tests are not good measures of a student's aptitude, then why do you keep using it? Why do you keep having different standards. Just drop the test altogether. If it's not a good measure, don't use it. Well, LSAC might lose out of money for other reasons. I'll get to that in a moment. But do you know why the schools didn't drop it? Yeah.
Is it because, like, I guess maybe not in college, when you come out of college, because when you come out of high school, it can be very, like, neighborhood based. So the people that work at the school could just boost all your scores, and then you could get into a higher college.
Inflation's real. Great inflation's real. So here's the fact. You may not like this. LSAT is a very good measure of what law school performance.
Really?
Just like a ranking thing.
The relation between LSAT and 1L GPA is pretty close. It's not perfect, but it's pretty good. Undergraduate GPA is a crapshoot because of inflation, right? And different majors are different. If you're like, engineering major versus like, liberal arts major, the grades are different. Just trust me on this one, it's true, right? LSAT is a very good measure. After the Harvard case, and this was during COVID too, a number of schools dropped the LSAT and SAT requirement, and they brought it back because they realized it was too much of a drop in quality. So schools employed these tests because they're measures of quality, but they started to use different standards for different students. All right. All right. What are we doing? All right. Let's answer questions in the majority. All right. Let's go on to the dissent. Yeah, the Justice Thomas dissent, I think I talked about a little bit, was really significant for the time because you had Justice Marshall writing decades earlier. In his perspective, but Thomas took the opposite one. And he says, like Frederick Douglass, I believe that blacks can achieve in every avenue of American life without the meddling of university administrators. He says that this deference to the law school is not consistent with strict scrutiny. The university can't both maintain high admission standards and grant exemptions to favored races. In other words, Michigan, you have a choice. You can have high standards that everyone has to meet, or you can have a standard that will admit more students and be less selective. You can't have both. And he goes off on the elites. He does not like elites. He does not. He says racial discrimination is not a permissible solution to the self-inflicted wounds of this elitist admissions policy. Okay. Then he says whatever is illegal today will be illegal in 300 months. Right? This 25-year clock thing is kind of silly. He then explains why racial classifications demean us all. Right? The very notion that some people need this boost treats them, he says, as an equal. Right? You're presuming they can't do it on their own, so they have to give this boost to them. He cites HBCUs, other institutions that are able to provide education to minority students without having these heightened standards. He cites Justice John Marshall Harlan and Plessy to call for a colorblind constitution. I mentioned at the time, everyone loves Plessy in the 1890s. But when it came time to the 1970s, like, wait a minute, we don't want colorblind. We want to see color for good purposes, not for bad purposes. Thomas rejects this distinction. Because the law school is concerned with aesthetics, the shape of desks, tables, and the colors of skin. And they presume that people with their skin color a certain way will necessarily have certain perspectives. The true interest is in racial balancing. Okay. He says there are race-neutral alternatives, dropping standardized tests, not having elite schools. But the interest is not simply diversity. It's a tool in advancing the school's interest, having a superior education for some groups and an elite institution. Okay. He rejects the notion that there's a state compelling interest of having an elite law school. This is this guy. Like, what percentage of grads actually stay in the state? Barely 15%. Almost everyone goes to the school and leaves the state. This is not a state interest in having an elite school for their own lawyers. It's been having an elite law school for their own reputation. Okay. There are also collateral consequences, right? He raises the idea of mismatch, which is very controversial that people don't always agree on it. He says, when you admit a student to a school where they cannot thrive, they're actually underserved. In other words, if a student could be admitted to school A, but they're admitted to school B, which is higher ranked, they may actually be worse off because they're not able to compete. Better be the valedictorian at lower ranked school than the bottom of your class at top ranked school. That much is probably true, right? This is sort of maybe a sensitive point, but it's true. You're all here for a reason. I think you all have the opportunity to thrive here, right? If I went to Yale, I think I would suck there. I wouldn't have done very well at all. I don't think I've done well at Yale. People tend to go to the schools where they will do the best at. And Thomas says there's a problem when people admit to schools they cannot thrive at. Now, there's a robust literature showing that Thomas is wrong about this, and I could talk about this for hours. It's called the mismatch theory. I'll Google it if you want, but just Thomas does make these points. I want to flag them here. Okay. He also cites the experience of California. In California, they adopted something called Proposition 209. What is Prop 209? This is California voters basically banned affirmative action. And the number of minority students dropped at UC Berkeley and other schools. Frankly, the UC schools basically violated Prop 209 for decades. It was pretty egregious. I'll just give you one example. The UC Law Review actually had a box on the way you submit an article when you're a law professor, you submit it to a journal, right? Law reviews. And they actually had a race box on their application. It was literally illegal, right? They're not allowed to consider race when they're publishing. And actually, I did some digging on this. And they said, well, the journal is not actually part of the university. It's a separate corporation. They tried to get around it. They had this entire legal apparatus to evade it. They were very good at these sorts of things. Okay. All right. What else? All right. All right. I think that's all I have on Justice Thomas's dissent. Any questions? Yes, sir.
Michigan, like today, would it be fair to say that race is still a factor in admission?
Well, at the law school, yeah, because they upheld it. Basically, what happened after this case was the undergraduate copy of the law school's model. Every law school in the country said, aha, Justice O'Connor said the law school's model is okay, let's copy it. The better question, though, is what's happened in the wake of the Students for Fair Admission decision. That's a far better question. I'll just give a preview of our next class. In the run-up to this decision, university said, we will not be able to maintain our diversity numbers. Not that there's a quota, right? But we won't be able to maintain our rates of diversity we have now. Magically, in the wake of that decision, schools have maintained their numbers. Some have. And that raises one of two possibilities, maybe more, but at least two possibilities. One, that the predictions they gave were just not accurate, and maybe they cried wolf. Second, they're cheating, and they're doing things they're not supposed to be doing. So there's going to be ample litigation following about whether they're actually following the Students for Fair Admission decision. But a lot of schools have not seen very large numbers. Now, it is true that higher ranked schools can still have their pick of the litter. They can choose who they want to pick, right? It's actually the middle tier schools that are having a more of a difficulty having their minority, I won't say quotas, but the numbers are seeking to achieve. Not that they ever will admit there's a number, they're still trying to achieve a number. Yeah. What else? All right, let me wrap up. You guys can go a few minutes early and get ready for the event at 1 o'clock. I have to get ready as well. When we're talking about scrutiny under the Equal Protection Clause, We have to always start off, at least in theory, at least, with what kind of classification we have. Is it non-suspect? Is it quasi-suspect? Or is it suspect? And based on the sort of classification you have, you then decide how much scrutiny you're applying. If it's non-suspect, it's going to be a rational basis standard. If it's quasi-suspect, it's a very intermediate standard. And if it's strict scrutiny, you apply a narrow tailoring standard, which is very hard to achieve. In almost every case of protection, you're going to find it's unconstitutional, with the exception of Grutter. That's sort of the outlier, although that's no longer in law. Okay. Anything else? All right. Thank you all so much. I'll see you guys on Wednesday.